Good afternoon, everyone. Thank you for attending our webinar today on the legal and policy implications of removing marijuana from its current status as a Schedule I drug. I'm Rachel Callanan, a senior staff attorney at Public Health Law Center, and I'll be moderating this webinar. We wouldn't be attorneys if we didn't start our presentation with a few disclaimers. First, federal regulation of marijuana is a complex and controversial topic. And because a lot is continuing to happen in legislatures across the country, it's also a bit of a moving target. Second, as far as terminology is concerned, we'll be using the terms cannabis and marijuana interchangeably. We'll also be using the term recreational marijuana rather than adult use marijuana. Finally, we consider decriminalization as the removal of criminal penalties and expungement of criminal records associated with marijuana, while legalization of marijuana describes the regulation of marijuana as a legal product primarily in the context of commercialization. The Public Health Law Center is a nonprofit organization founded in 2000 and is located at Mitchell Hamlin School of Law in St. We're a team of attorneys and policy experts that support commercial tobacco control, healthy eating, and active living policies at the local, state, and national levels. The photos here are of our commercial tobacco. Our speakers today are Carrie Cork, who's a senior staff attorney at the center, and Hudson Kingston, who's a staff attorney here. We provide free legal technical assistance to public health advocates and professionals around the U.S. in several ways, through legal research, policy development, and a wealth of publications and resources, which are all available on our website. We also do presentations and training, such as this one. What we don't do, we don't represent clients and we don't lobby. Our comments today are based on our experience over the years with issues involving the regulation of tobacco and related products. Despite the many differences between tobacco and marijuana regulation, there are also telling similarities. We explore many of these intersections in two recent publications, Toking, Smoking, and Public Health, and There is No Constitutional Right to Smoke or Toke, which are both easily accessed on our website at www.publichealthlawcenter.org. Our organization is committed to the principle that advances in public health cannot be achieved without addressing equity. This slide highlights one of our publications about the importance of equity considerations in public health policy. In the context of marijuana policy, this orientation means that decriminalization should be a cornerstone of any regulatory changes. Our focus is on achieving health equity and correcting inequities that current and historical marijuana policies have had on communities of color and African American communities in particular. Today's webinar explores the many ways that marijuana could be regulated if it were no longer treated as a Schedule I drug. We won't be exploring in depth the important legal issues that arise with the decriminalization of marijuana, including expungement. But social equity issues need to be considered in any thoughtful and serious discussion of marijuana legalization. And just a few quick notes before we get started. We have applied for CLE credit for this 1-hour webinar. And also, as Jay mentioned, we'll be fielding as many questions as possible at the end of this presentation. We'll do our best to follow up with anyone whose questions aren't answered. Finally, after the webinar, we'll be sending you a short survey. We hope you'll take a minute to complete that. And with that, I'll turn things over to our first presenter, Carrie Cork.
Thanks, Rachel, and thank you all for attending our webinar today. Okay, here's what Hudson and I plan to cover in this session. We'll take a brief look at the history of the Controlled Substances Act and the conflicts between state and federal law, which set up the cannabis conundrum. Then we'll plunge into a description of 4 possible approaches to the current federal posture on marijuana and discuss some of the possible benefits, drawbacks, and unintended consequences related to each approach. Finally, we'll wrap up with some closing thoughts. So let's start by putting scheduling into context. Back in October 1970, President Nixon signed into law the Controlled Substances Act. This statute establishes federal U.S. drug policy under which the manufacture, importation, possession, use, and distribution of certain substances is regulated. One of the key sections of the act is a division of all drugs and other potentially harmful substances into 5 distinct categories or schedules, depending on the drug's acceptable medical use and its potential for abuse or dependency. Here are the 8 factors used to classify a drug or to consider whether a substance should be rescheduled, which means it's moved from one schedule to another, or descheduled, which means it's removed from the Controlled Substances Act altogether. 2 federal agencies are charged with analyzing these factors to help determine which substances are added or removed from the Controlled Substances Act. The Drug Enforcement Administration, DEA, which is an arm of the Department of Justice led by the U.S. Attorney General, and the Food and Drug Administration, FDA, which is an arm of the Department of Health and Human Services. And here's a quick reminder of the types of drugs that are grouped under each of these 5 schedules. They involve progressively fewer restrictions as they move down the schedule, from drugs believed to have the greatest risks of harm, such as heroin, which is a Schedule I drug, to the drugs considered less dangerous, such as cough syrup, which may contain a small amount of codeine, a Schedule V drug. Schedule I drugs, including, of course, cannabis, are the most tightly controlled of all the drug schedules. This most restricted category is reserved for drugs with a high potential for abuse that have no accepted medical value and lack any level of safe use, even under medical supervision. Substances in this category cannot be prescribed or consumed, and very few clinical studies are permitted that involve the substance itself. Although Congress created the original listing of controlled substances, as I mentioned earlier, 2 federal agencies help determine which substances are added or removed. There are 2 ways by which the scheduling of marijuana can be changed: congressional action and administrative action. Congress has the power to reschedule or deschedule marijuana through new legislation specific to marijuana or through tailored amendments to the Controlled Substances Act itself. The Act also provides for a rulemaking process by which the U.S. Attorney General can reschedule cannabis administratively. Either the AG or the Secretary of Health and Human Services can initiate that process. And a third option is by petition from an interested party. Several interested parties have submitted petitions recently seeking to change the scheduling of marijuana. None have been successful to date. One main reason these petitions have been unsuccessful is that the DOJ cites the U.S.'s international drug treaty obligations as a rationale for maintaining marijuana as a Schedule I drug. The U.S. is a party to several UN treaties that impose international obligations related to the control of marijuana. These treaties generally seek to curb the use of controlled substances while carving out exceptions for medicinal and scientific uses. The main governing treaty in international drug control is the Single Convention on Narcotic Drugs. More than 180 nations have agreed to this treaty. The Single Convention imposes restrictions on the manufacture, distribution, and trade in narcotic drugs by establishing a multi-schedule classification structure that applies varying controls for each schedule. The treaty classifies cannabis as a serious drug, subject to the agreement's most restrictive controls. And this is important because the Controlled Substances Act obligates the Attorney General to set controls on cannabis that are consistent with the requirements of the conventions. And as I just mentioned, the DOJ has often cited these treaties as a primary reason to maintain marijuana as a Schedule I substance. Also, the U.S. has historically been the primary driver in putting cannabis into the most restrictive schedules in international treaties. So there's some cognitive dissonance if the U.S. now reduces its own restrictions. Modifications of these treaties may be slowly in the works now. The FDA recently solicited comments on this very issue at the behest of the World Health Organization, which is seeking to modify the scheduling of cannabis under the Single Convention. Okay, back to the U.S. As I mentioned, any rescheduling of marijuana would involve the FDA. The FDA's role in the regulation of drugs, including marijuana and marijuana-derived products, also includes review of applications to market drugs and to determine whether proposed drug products are safe and effective for their intended use. The FDA's drug approval process requires that clinical trials be designed and conducted in a way that provide the agency with the necessary scientific data upon which the FDA can make its approval decisions. Without this review, the FDA cannot determine whether a drug product is safe and effective. Also, as you know, in 2009, Congress gave the FDA broad authority to regulate tobacco products. The FDA has a lot on its plate, but even so, many of us in the tobacco control community have been disappointed over the years with the pace and scope of the agency's tobacco regulatory efforts. And tobacco research dwarfs marijuana research in every respect. Hudson will talk more about this, but suffice it to say that the prospect of FDA oversight of marijuana products, particularly recreational products, is unlikely to inspire confidence among many in tobacco control. Okay, so I mentioned international drug treaties as a conundrum. Any talk about research and marijuana leads us to yet another conundrum. Keeping marijuana as a Schedule I drug severely restricts the ability of scientists to study its potential medical benefits. At the same time, the lack of scientific research on medical use is offered as evidence for keeping marijuana in Schedule I. As you know, for Schedule I drugs, and in particular the marijuana plant, it's very difficult to do research. Only certain researchers can get the certification and licensure necessary to handle the drug, the funding to study it, and the approval from university institutional review boards. Researching marijuana is a cumbersome, expensive, and time-consuming process, but that research is what will inform the medical community of marijuana's medical use. Federal policy hinders the very research needed to justify rescheduling the drug. These headlines from journal and news articles demonstrate how discouraging and exasperating the marijuana research process has become. Thanks, Joseph Heller. Despite this regulatory predicament, the FDA has recently approved Epidiolex, a cannabis-derived oral solution used in the treatment of seizures associated with two rare severe forms of epilepsy. This is the first FDA-approved prescription drug derived from the marijuana plant. The FDA has also approved two other synthetic cannabinoids to treat nausea and vomiting associated with chemotherapy. Before we move to a discussion of federal regulatory approaches for marijuana, it might be useful to keep in mind the vast systems and structures in place to regulate other common products and substances. Here, for example, are just a few of the federal agencies with regulatory responsibilities for alcohol. And here are a few of the federal agencies that regulate opioids. Despite all these regulations and resources, we're still in the midst of an epidemic. Finally, here are some of the federal agencies charged with regulating tobacco. Keep in mind that there's a lot of interagency collaboration and coordination across these federal regulatory systems. Now back to the four regulatory options we'll be discussing. This is somewhat like an adult version of the choose your own adventure stories that were so popular when many of us were kids. I'll talk briefly about the first two options, maintaining the status quo and what we're calling cooperative federalism. And then Hudson will talk about the next two choose your own adventure options. As we all know, marijuana has been classified as an illegal substance under federal law for almost 50 years. It's a federal crime to cultivate, manufacture, distribute, sell, possess, purchase, or use marijuana, and violators are subject to fines that could range from thousands to millions of dollars and substantial prison time. That the states are able to pass their laws legalizing marijuana is only possible because the federal government allows them to. The authority under which cannabis enterprises continue to operate despite absolute prohibition under the CSA is a series of memoranda issued by the U.S. Justice Department under the Obama administration. These memos, the Cole and Ogden memos, allow state-approved and regulated operations to exist so long as they do not violate certain areas of DOJ's concern, such as selling to minors or engaging with drug cartels. The DOJ's exercise of prosecutorial forbearance could change at any time, depending on the administration. In fact, when Jeff Sessions was the Attorney General, he rescinded the Cole and Ogden memos. However, despite that dramatic action, which got a lot of headlines, it appears not to have changed the practices of the federal government. And here is a status quo reminder. You have a map which keeps changing. 33 states, DC, Guam, and Puerto Rico currently legalize medical marijuana in some form, and 10 states in DC permit recreational adult use. The number of states with recreational laws could double by year's end, including states in the Midwest, such as Illinois. So what are the benefits of the status quo? Well, not a ton. Of course, it varies depending on who you ask and where you live. Marijuana businesses and consumers are probably pretty happy in the states that have legalized recreational marijuana for sale and allow use. Some in law enforcement may see benefits to directing their energy elsewhere. Our current federal posture ensures we're in compliance with international trade drug treaties, and states are generally regulating marijuana with a light touch, meaning growers, manufacturers, and retailers don't have to jump through a lot of hoops now. This could change dramatically if the federal government acted and created the kind of regulatory structures we have for alcohol or tobacco. It's a lot easier to find drawbacks of the status quo than benefits. The inconsistency and outright contradictions between state and federal law create a cloud of uncertainty. The status quo and lack of regulations has set up a dynamic that promotes social normalization of use. The illicit market persists even in states with legalized recreational sales. There's little funding to invest in proactive regulatory planning and the critical research needed to understand what does and doesn't work. Finally, the selective enforcement of criminal laws persists, and the legacy of the war on drugs continues to damage lives and communities. That low-level marijuana offenses are subject to criminal prosecution at the federal level and in some states remains the biggest drawback of the current federal stance. It's not possible to have a fair policy discussion about marijuana and the Controlled Substances Act without acknowledging the harm to communities, particularly communities of color and African American communities, caused by the war on drugs. African Americans are nearly 4 times more likely than whites to be arrested for marijuana possession, despite having roughly the same prevalence of use. 16% of African American children have had a parent incarcerated, compared to just 7% for non-Hispanic white children. Incarceration for low-level drug offenses and the implications of being labeled a felon on one's ability to get a job, housing, education, or to vote does incredible damage to communities. Given time constraints, we can't dive deeply into this issue, but we need to keep in mind the civil rights and social justice issues related to the status quo, as well as decriminalization and related measures that could help undo these harms, such as allowing people to seal, expunge, or reclassify a range of marijuana convictions on records. Other drawbacks? Well, as I've already mentioned, marijuana's Schedule I status has had a profound impact on the ability of researchers to conduct trial studies of cannabis. Research funding is limited. High-quality cannabis for research is scarce. No standards have been set for the purity and potency of marijuana, resulting in varied quality and dosage. And lack of research prohibits a robust analysis of public policy, which is particularly concerning for public health practitioners. Also, because marijuana is federally illegal, there's no federal regulatory oversight, nor are there quality control standards in areas such as agriculture, production, and manufacture, which is why you end up finding hazardous natural contaminants and artificial adulterants, as well as pesticides and other fun chemicals in cannabis products. It also means that selective breeding of marijuana species has resulted in a more potent psychotropic effect and greater risk of adverse effects than in the past. There's also a lack of collaboration among federal agencies and states that have legalized marijuana in sharing their understanding, preventing current harms, and forecasting industrialization effects. Drawing from our experience with tobacco, the free market approach clearly failed to protect the public's health and common good. In spite of recent federal regulation, tobacco use remains the leading cause of death in the US, and tobacco companies continue to exert an incredible amount of influence. There are very real concerns that a rapidly growing and increasingly profitable marijuana industry may come to resemble the tobacco industry. Lack of coordination among federal agencies and among states that have legalized marijuana creates fertile ground for the growth of big weed. Finally, the implications of marijuana's current regulatory status include lack of commercial banking, tax challenges for marijuana businesses, limited access to legal services, and employment and family law repercussions. As you know, the status quo approach hasn't exactly been without controversy. Marijuana's Schedule I classification in particular has been repeatedly challenged in all branches of the federal government since 1970. The first petition to reschedule marijuana took 22 years before a decision was issued, and subsequent federal petitions have also taken years to be decided. In recent years, a raft of petitions and bills have been introduced to regulate marijuana like alcohol, to reclassify marijuana to Schedule I or to Schedule II, to deschedule it completely, clarify banking rules, and so on, including the States Act, which I'll discuss in a minute. Most recently, the bipartisan 2018 U.S. Farm Bill, or Hemp Farming Act, became law, which legalizes hemp. It doesn't create a system in which people can grow it as freely as they can grow tomatoes, but it does enable hemp to be grown as a highly regulated crop in the US for both personal and industrial production. So that's where we are today. Now let's talk briefly about another scheduling approach, which has been called cooperative federalism. Advocates have described this as a common sense approach. People backing this approach sell it as a big improvement over the status quo, but it's probably more of an incremental change to the existing system. With this approach, the Controlled Substances Act would be amended to exempt marijuana activities that are lawful in the jurisdictions where they occur. It codifies the approach taken by the Cole Memo, making it more permanent than an AG guidance or agreements between states and the AG regarding enforcement. Among other things, this approach would give lawmakers greater flexibility in non-legal states to reform their laws in a manner that reflects the will of their constituents and regulates cannabis commerce. You may have heard of this approach lately, since it's largely reflected in a bipartisan bill introduced in 2018 by Elizabeth Warren and Republican Colorado Senator Cory Gardner, called the States Act, which stands for Strengthening the 10th Amendment through Entrusting States. It removes the threat of federal intervention and prosecution in states that regulate marijuana use and sales. This approach is similar in some respects to the approach that Canada's legalization of marijuana has taken. Canadian provinces have a lot of say in how to regulate this drug. In some provinces, weed will be illegally sold only in government stores, in others only in private stores, and in yet others, there's a mix. So what are the benefits of this approach? Well, it doesn't force legalization on any state that doesn't want it. It respects the rights of voters in states that said, this is how we want to do business around marijuana, and we just want the federal government to get out of the way and let us do it. It essentially allows states to work as laboratories of a democracy. And as you can see, it also provides consistent legal norms which solve critical conflict of interest and law concerns, result in a more comprehensive federal regimen than the current approach, and would provide some stability for medical users and suppliers. This approach has been endorsed by some leading legal scholars. In fact, several high-profile US senators And recently, the attorneys general of most states asked Congress to consider a cooperative federalism approach to marijuana banking. Under the bill that these AGs are asking Congress to pass, the Safe Banking Act, financial institutions that service legitimate marijuana businesses regulated in their states would no longer risk being penalized by federal financial regulators. SAFE stands for Secure and Fair Enforcement. Why did so many AGs get on board with this proposal? Well, this bill would protect medical marijuana businesses, which exist in far more states than those that allow legal recreational sales. Still, there continue to be definite drawbacks to the cooperative federalism approach. It may solve the unpredictable tension between the federal government and states that legalize marijuana, but it still do little to enable much needed research into marijuana harms and benefits. It wouldn't bring products into FDA purview, reduce the likelihood of the big marijuana industry, prevent tobacco industry appropriation, address treaty conflicts, or solve other problems caused by the current approach, such as the impact on social justice and so on. So that's cooperative federalism in a nutshell. And now Hudson will talk about a few more choose your own adventure regulatory options. And this is where the adventures really begin.
All right, thank you, Carrie. My name is Hudson Kingston, as has been foreshadowed. I'm a staff attorney here at Public Health Law Center. And as Carrie said, this next chapter is the one we called Let's Get Radical, full-on descheduling. What I mean by this is totally dropping marijuana out of the CSA without any public health protections in relevant law. This might seem a little extreme and theoretical to most of us. Surely Congress isn't intending to do this, right? Well, at least one bill out there already calls for wholesale descheduling. If you're from Oregon, you might be familiar with Earl Blumenauer's HR 420, the Regulate Marijuana Like Alcohol Act. It's a very short law, longer than the screen capture I have here, of course. But this law, in the bit at the bottom with the arrows, would indeed drop marijuana right out of the CSA and wouldn't really do much more than that to assign a little authority to the Department of Alcohol, Tobacco, and Firearms, change their name to add the word marijuana. But there wouldn't be a whole lot there for public health. And any violation of marijuana laws would get a maximum $1,000 fine. For an industry that's going to be billions of dollars big soon, that's what you might call deregulation. Now, when thinking about this descheduling, I want you to remember that you can't spell deregulation without regulation. That is to say, there are quite a few laws out there already that could spring up if agencies, federal agencies, all of a sudden aren't prohibited from interacting in any way at all with legal marijuana. Dropping marijuana from any schedule would allow for positives, like a lot of new research. And it would be a huge headache for quite a few agencies, such as Customs and Border Protection, the FDA, the EPA, and as mentioned, all the banking regulators, who would suddenly have a lot more work to do in interpreting existing laws, writing regulations, and enforcing these. So just one example. Under existing law, the EPA has authority over pesticides. It sets both the amount you can use on crops and the amount that can be left as a residue on food and animal feed. As you might know, marijuana growers are currently using dozens of pesticides on their crops, mostly illegally. And states that are regulating recreational sales are having a tough time doing a job that they normally don't have to do for any other crop. They have to vet pesticides use and its application in a way that EPA normally takes care of. This would change under descheduling. So following the recent Farm Bill, we've discovered that under existing law, EPA is using temporary exemptions to allow limited use of pesticides on hemp. But other than a very small number of hemp seed products, none of these are cleared for use as food, and the EPA has not been able to change regulations that govern pesticide limits on hemp as food. There are currently only 2 such standards on the books, and one is just for animal feed. Therefore, there is only one approved limit on hemp seeds as food, none for non-hemp marijuana products that are used as food. If marijuana were suddenly descheduled, though, the definition for food would be met. Edibles are being sold already. EPA has to would be forced to set many new pesticide residue limits for foods. And then the dozens of pesticides being used illegally under federal law by growers would suddenly become a major regulatory headache for the EPA, for the pesticide makers, and for the marijuana industry. Unless growers quickly switch to only using the one relevant pesticide, which has its own problems, or none at all, they found some way to totally clean all pesticides from their crop, you have a serious ongoing violations of pesticide laws that the EPA doesn't have any authority to ignore. Normally, these processes of adding new uses of pesticides take a long time to get through, and the burden of getting a chemical approved is borne by the pesticide company, so think Monsanto. Even if they did line up to immediately apply for standards on marijuana edibles, the process normally takes years and a notice and comment rulemaking at the federal level. So what's the tobacco corollary and how does it look? Well, it's not good. The USDA had set pesticide limits on tobacco in the 1980s, and these pesticide limits have not been updated. They're really out of date, and they concern pesticides that aren't actually legal to be used anymore in the United States, and they don't address ones that are being used. So, taking a page from tobacco control, there is a concern here that there would be the same sort of situation if the tobacco industry got its way or in some way moved in a large way into this industry. So the question really that I over foreshadowed there is whether the marijuana industry will benefit from the tobacco style exceptions to health focused laws, or whether it will have to abide by the laws that your strawberries and soybeans begrudgingly go through. Will they be as unregulated as the tobacco industry that has successfully fought for broad exceptions, or will they be tightly regulated, sort of as the alcohol and, again, tobacco industry can be in certain areas, like tax? It seems that the future here depends on how much political power the industry would have and in one of these descheduled futures. Well, what do we think would happen under descheduling? There's several possibilities. There would be the ready investment and banking access that Carrie already talked about. There's the potential to change federal law, which could net the industry billions of dollars over the next decade. Currently, they aren't able to mark off certain business expenses, but that could easily change. And then the increased certainty in the market invites larger investors who are more than happy to take risks once they know that there is a federal system that will allow them to do this type of business. So in summary, this is going to lead to massive industry expansion and consolidation. So how does this relate to public health? Well, I want to talk about two issues that industry and power and structure have over ways they influence public health. The first is diversion to other states, but we'll get to that second one soon. First, what is this? It is the diversion of legal marijuana in one state to another state, any other state. It is not allowed by the Cole Memo, and so all states that have legalized thus far have made it illegal to divert marijuana over state lines, including states where it is also legal under that state's law. But in the immediate aftermath of federal descheduling, those state laws would still exist. As we'll see, there's a good reason to think that that could quickly change, having a big impact on the industry. So this is still the status quo. And today I want you to imagine legal force fields between these states. Even though California and Oregon both have legal recreational sales, it is not legal for those products to cross state lines, something that the Oregon industry is already lobbying to change so they can export to a bigger market. Like I said, this is based on the Cole Memo that Jeff Sessions officially canceled, but which was controlling on how states arrange their legislation regimes. Now, under descheduling, any federal pressure to keep these force fields disappears. Then the growers in Oregon could mount a case against California under the US Constitution because states are barred from unduly regulating interstate commerce under the Commerce Clause. While Congress can maintain what I'm calling force fields, states would have to have very strong reasons for keeping out other states' product. And if other states could meet California's product standards, for example, it seems likely that all of these arrows of interstate trade between legal recreational states would mean fewer, bigger, stronger marijuana businesses. Similarly, the US is between one country that has legal marijuana and one that is likely to soon legalize marijuana. We also have an agreement with both of them that is currently called NAFTA. Under NAFTA, The three countries and their subnational states can't keep out products that are produced in other countries within limits that are similar to the Commerce Clause. If a Canadian company that has an atrocious environmental or labor standard could produce a product cheaply that it met the standards of Oregon's regulators, they could sue the US under NAFTA in arbitration called investor state dispute settlement. So for example, if Oregon tried to keep foreign products out of the state because they just wanted to make sure that their industry was protected, there would be very costly and long dispute. And in the end, the big arrow on the map might end up being the tunnel of marijuana commerce between the three countries going through the West Coast wall of legalized states. What does this mean? If it happens in this way, there are several big concerns for public health. First of all, a race to the bottom where businesses with the worst practices have the highest profit margin and can push everyone else out of the market, making a very cheap product. Concentration of power in a very few companies, so think of Philip Morris or Budweiser's InBev. And unlike tobacco or alcohol, these industries would consolidate virtually overnight, well before federal regulators had a chance to establish standards of how they are going to be controlled. So our second concern in public health is diversion from the legal market to the illicit market. This is where overproduction isn't stored in a warehouse for next year, but is instead sold tax-free to youth or other consumers in an unregulated manner. As you may know already, this is a very old problem predating legalization of either medical or recreational marijuana. In fact, it was the main plot point of a film that we all may have seen at some point. That's right. The notable cautionary tale, Half-Baked, where Dave Chappelle is a wily janitor who diverts research marijuana to illegal sales in order to get his friend out of a marijuana-based jam. This movie does not have a public health focus, is not particularly politically correct by today's standards, but perhaps if you see it later, you can consider it research. Moving on, what would happen to this type of diversion under descheduling? It's murky, but it could grow and have a higher toll on public health if either education or regulation falls short. Under descheduling, it's not clear how much the federal authorities would be policing the illicit market in legal states. They may leave it alone entirely. A recent proposal by Chuck Schumer would have federal enforcement against the other kind of diversion between states, but it didn't really mention what would happen in legal states, which of course would leave all the cost on states. There's a corollary for alcohol and tobacco of illicit sales, of course, which has taken a long time to get through to retailers that they really shouldn't be selling to minors or those that provide to minors. In tobacco control, compliance checks of retailers for underage sales are a large cost that is borne by all levels of government. It's not clear that everyone selling marijuana is likely to abide by minimum legal sales ages without such comprehensive and expensive enforcement. So one way states could try to deal with diversion or other projected harms to public health is adopt radically different forms of legal sales or provision that are being tried now. The Rand Corporation analyzed and discussed a dozen such models where the US states that legalize are only trying 2 of the available options right now. The standard commercial model is perhaps the worst for public health and the one that we see most in the United States right now. Here are Rand's 12 options and a link to the full report if you'd like it. You'll see the standard commercial model is all the way over to on the end to the right with prohibition over to the left. The options in the middle don't go as far as states have done this far and could be better for public health. These would also be available to states under descheduling in a way that they are not really available to states right now. But the standard commercial model is prevalent in the US, and so we'll dwell on it a little bit longer. What is the standard commercial model? Well, it's what Colorado, Washington, and the rest of US jurisdictions have done when they allow legal sales of recreational marijuana by for-profit private businesses. It tends towards creating an efficient market and maximizing tax revenue. That's why Colorado and Washington gave primary authority to the taxation and licensing agencies instead of the health department. It's questionable whether that is good for public health as opposed to good for private investors. The Rand's take and their hypothesis is that giving the authority to the health department instead would be a mixed bag. On the plus side for public health, the health department would likely minimize growth of users and use while making sure that there's enough product available to curtail the illicit market. But health departments generally don't want to do a lot of police work, and they don't generally collect taxes. They don't generally inspect licensees on a regular, unannounced basis. While these agencies would likely be the best leaders for public health, they would have to acquire new skills, or they would have to do a good job coordinating work across a large number of agencies, potentially making the regulatory regime a lot more complex. For an idea of other models that can protect public health, we can look to Uruguay, Canada, and Amsterdam. You might think of Amsterdam, for example, as a place where anyone can get marijuana, but as the Netherlands Embassy in the US reminds us in this sassy tweet from 2015, in DC, you can walk around with 11 times as much marijuana as you can in Amsterdam. This is a result of our standard commercial model and the way that we have loosened existing regulation by criminal sanction instead of adopting other structures. So what options are out there? RAND likes the state monopoly for public health. This is being tried out in Quebec, incidentally, and it seems successful thus far. There are other options, some of them from other countries with existing policies. Uruguay allows cooperative production akin to home growing, but in a group, and has very limited sales as compared to legalized US states. From our perspective in tobacco control, RAND's conclusions and suggestions seem pretty valid. Strong local control and limiting license numbers and clustering are known to work for tobacco retailers. We also know from US alcohol policy that government monopolies can lead to a better public health outcome. I'm also very interested in the public utility model, where there's a private monopoly that is highly regulated by the one regulator. This could cut down on a health department's need to track many businesses and instead allow them to focus on keeping a very close eye on a few actors who are not allowed to do any business beyond defined service areas. This is incidentally the de facto way that the Minnesota medical marijuana system works right now, with only 2 companies being able to participate in it. Quick digression off to free speech. This is a quick discussion on what states could do, but please note that most states aren't regulating marijuana advertisements as thoroughly or as harshly as I'm suggesting in this quick discussion. Right now, marijuana sales are illegal under federal law, so advertising marijuana sales is in no way protected by the US Constitution. States can regulate advertising how they want, up to and including prohibiting all advertisements. And a retailer's lawsuit against such a prohibition would likely fail unless they were able to proceed only under state law. The industry hasn't really bothered to sue over existing restrictions, and this might be a product of their realization that it has a low chance of success. All of this would change under descheduling. When states become legal, truthful advertising becomes commercial speech, something that the Supreme Court has decided gets protected under the Constitution. States can restrict commercial speech, but must base it on a substantial government interest. The interest must be directly advanced by the control on speech, and the control cannot be more extensive than necessary. So what have we learned from the cases on this? Well, in the tobacco industry, companies have successfully and aggressively litigated against restrictions on the placement and kind of their retail advertisements. The sugary drink industry has successfully litigated against warning labels placed on their products. So states can do some things to restrict commercial speech, but the chances of litigation would rise quite a bit under descheduling, and the policies would have to be much more carefully adjusted to be narrowly tailored to the exact purpose that you have in mind. So just to summarize, descheduling has some benefits and drawbacks. Research would be a lot easier, and states would have a lot more options in how they could structure legalization. And there is the possibility that federal involvement would increase some public health standards, but the industry would become gigantic overnight. It's unclear if federal policy would really be hands-off and would therefore leave more for the states to do. And the industry would potentially have additional powers under the law when it was no longer a Schedule I drug. Moving on to our 4th topic, what would happen automatically if CSA stayed in the CSA, but was rescheduled, say to 2, 3, 4, or 5? Well, nothing. Nothing changes immediately, but many things become possible that are mostly impossible now. If marijuana were rescheduled, researchers again would be impacted. At least one proposal would create a new schedule, Schedule 1R, just to put marijuana there and allow it to remain very illegal but researchable. This is more of a researcher's dream potential than it is a piece of legislation that's about to pass. Additionally, under a different schedule, the idea is that the government, the already existing idea that the government is using its prosecutorial discretion to wait and see about marijuana becomes stronger. That is to say, marijuana is finally recognized to have possible medical benefits, and then it would be good to actually study it. The FDA could more seriously look at marijuana, CBD, and other substances from the plant for medical uses and that could eventually be approved as drugs. As Carrie said, one drug has already made it through this process, and it was rescheduled by administrative action to Schedule 5. It's a strong CBD drug that's used to treat rare childhood epilepsy. This drug is actually produced and was studied abroad, which is something that wouldn't have to be the case under rescheduling. But there are some caveats I'd like you to keep in mind. Smoked marijuana is not likely to ever be an FDA-approved drug soon, well, or maybe ever, because it varies wildly in potency and content, and breathing smoke has significant health harms in all instances. There are only a small handful of FDA drugs that are sold over the counter or by prescription that come directly from a plant because it is so hard to get a consistent product. At the same time, the federal government doesn't have a great way to close all the existing facilities. So even though they would be selling something that is now a drug under the law without FDA approval, which is illegal, state legal businesses could be able to continue in this legal gray area and perhaps continue limping along for quite some time. So just to summarize all that again, one of the big points here is that there's more ability to do research, but this would be less radical in most senses than descheduling. It would leave the FDA in a very strange position, and it doesn't really account for or resolve the existing markets in most states where they're already selling either medical or recreational products. Also, as we know from the opioid crisis, scheduling something even at Schedule 2 does not necessarily protect public health. It certainly would allow more FDA-approved drugs to go through the regular process, but it would create a lot of new and strange legal gray areas. So where does that leave us? We just want to remind you, we don't have all the answers, but we do have guiding principles that we hope guides everyone's work on this. We know it's important to us. We try to combine the best available evidence, which is hard in this area specifically, with equity and the opinions of key partners. We also support strong enough regulations at the federal, state, and local level to innovate better policies over time and address public health issues as they arise and become more well understood. And with that, I'll turn things back to our moderator, Rachel Callanan.
Great, thank you for your presentations, Hudson and Carrie. So we have a few minutes for questions now, and we have a couple that have come in here. So the first is for Carrie. The question is, you mentioned that there have been a lot of proposed legislative efforts to regulate marijuana. How many bills are you talking about?
Oh, that's a good question. It changes daily. It's really amazing how many of these cannabis-related bills are moving through state legislatures and Congress this year. According to an organization called Marijuana Moment that tracks this legislation, there are roughly 1,120 bills that have been proposed and are being considered to date. And these bills cover a range of issues such as zoning ordinances for medical cannabis dispensaries, marijuana use and gun rights, marijuana social equity programs, marijuana packaging and labeling rules, CBD regulatory systems, and so on.
Great, thank you, Carrie. So there's another question that's come in here. This one is for Hudson. How would the descheduling of marijuana impact the decriminalization of marijuana?
Great question. Yeah, it's sort of similar to what I was talking about before. It might be a first step, but it wouldn't lead automatically to decriminalization. Most of these things are criminalized at the state level, and that's where most of the enforcement is happening. So even if something becomes descheduled at the federal level and then federal criminal law is changed to add decriminalization, there would still need to be actions at the state level. And this is sort of why, in a sense, decriminalization at the state level works, even though it creates a gray area. Delisting or descheduling, at the federal level doesn't have some sort of automatic effect to clear all books of these laws. And one good example of this is in the descheduling of hemp. It allows, as Carrie said, allows the production of hemp, but it doesn't decriminalize or in any way allow the selling of CBD products as food, as lotion, as herbal supplements, all of the ways you see them in the gas station right now. Those things did not get affected by the descheduling of hemp, and that would also be the case for marijuana.
Great, thank you, Hudson. Another question that has come in, and I think this one's also for Carrie. I've heard about something called the Carers Act that's received a lot of congressional support, and that which reschedules medical marijuana. Could you explain more about that bill?
Okay, the CARES Act is a bipartisan bill. It stands for Compassionate Access, Research Expansion, and Respect States. And it's been, some version of this act has been proposed since 2015. It aims to protect the medical marijuana patients, providers, and their families, and allows states to control their own policies on the issue. It's supported by many health and veteran organizations, and it, for example, it allows the U.S. Department of Veterans Affairs to issue medical marijuana recommendations for patients. This is something the department has not done in the past, and it establishes a new separate registration process to enable medical marijuana research. So we'll just have to stay tuned on where we are with that bill. Thanks.
All right, great. Thank you, Carrie. And it looks like we have one more question. So in states that have legalized both medical and recreational marijuana, are there lessons for how federal legalization might approach this two-track regulatory approach?
That is a tough question. This is Hudson again. So there's obviously lessons in treating it differently between the two, but because the federal government has so much more existing authority over things like drugs and medical devices and things like that, they also have a lot more experience. I would say that what the feds can learn from the states is perhaps the enforcement pitfalls and sort of the difficulties of trying to allow a quote unquote new industry to move from being actually very strong and in some ways well-run illegal market, move it into the light and also at the same time talk those same people into accepting a higher level of regulatory burden than they would ever be used to. So I think there's a lot of lessons there. I do think that the FDA's existing drug system is not going to go away or automatically approve medical marijuana as we see it in states anytime soon. But perhaps there are pieces of legislation, as Carrie said, there's too many to know that would somehow validate medical marijuana as a drug, even though that does not seem possible under FDA standards.
Great. Well, thank you both for this great information in a rapidly evolving area of the law. And I just want to note for the attendees today, this webinar will be recorded and posted on our website in the near future. And the slides will also be posted on the website for your use as well. Please follow up with any other questions that you may have. And with that, we will close the session. Thank you for attending our webinar.